Welcome, everybody. We are so thrilled for those of you who are able to join us in person tonight and those of you who are joining us via live stream. This is being put on by Benedictine. As some of you may or may not know, we are a service provider for developmentally disabled children and adults. We have a school in Ridgely, and we also have adult residential group homes, day program. We are in our Easton office where we provide job training through the DOORS program, which means we work with the local public school systems in Caroline, Talbot, and Queen Anne's counties to provide job training for those special education students. We are one of the larger nonprofits in the area. We serve students statewide and also folks here on the Eastern Shore. So tonight we're focused on estate planning. Some of you are parents and family members of those with special needs, and some of you are just here for the estate planning piece, so we're happy to have everybody join us. I want to introduce our presenter tonight, Tara Frame of Frame and Frame. She has her BA from Johns Hopkins University and her JD from the University of Baltimore. And her father founded her firm over 70 years ago. Serves both the Eastern Shore and Western Shore, with her focus being on estate planning. She enjoys developing long-term relationships with her clients. And we'll ask that you wait until the end to ask questions. And we'll also follow up after and email you if you gave us your email with slides. And also a link to the video if you'd like to watch it. So thank you again for joining us and enjoy.
Thank you. Hi, everyone. Thank you so much for coming out tonight. I know it's rainy, so it's hard to get out in the rain. But I think this is a really important topic, and I know many of you have questions about this topic. We only have about an hour, so I am going to present for about 45 minutes, and then we'll have questions 15 minutes at the end. So maybe, if you have a pen, write down your questions so you can remember to ask them at the end. She said, my name is Tara Frame, and I am the senior partner at Frame and Frame. My father founded the firm in 1954 as a general practice firm. I started there in 1996. And took over the firm after he passed away many years ago. But we do focus on estate planning, probate, elder law, and special needs planning. Unfortunately, when people don't plan ahead, one of our attorneys focuses solely on estate and trust litigation. So we try to encourage everyone to plan ahead to avoid your family having to go that route and being involved in litigation. We also have one of our attorneys focuses on special needs planning. I was hoping she would be able to come with me tonight, but she is actually on vacation with her husband in the next 2 weeks, so she couldn't make it. So we're going to go over estate planning 101 and special needs planning. This is fairly basic information, but important information. So I won't get into too much detail or drill down just because of the time limits. But if you have any questions afterwards, please feel free to reach out to our office and we can help you out. With that being said, I just want to, before I forget, if anyone, we usually charge a consultation fee, but if you did call our office and you wanted to book a consultation, we will waive that if you let them know that you attended this presentation. Go ahead. So what comprises your estate plan? Often people say, well, I don't need an estate plan because I don't have an estate. Well, your estate is anything you own. So if you have a house, if you have a car, if you have a bank account, that is your estate. So when we say estate planning, we are planning for the distribution or disposition of those assets when you pass. So the 4 basic pieces of an estate plan would be your last will and testament or your trust. You would have your durable financial power of attorney, your medical directive, advance directive or living will, and your appointment of healthcare agent. And why is estate planning important? Well, you want to provide for your family when you're gone. If you have any children or grandchildren or other family members with special needs, it's very, very important to consider their needs when you are no longer with us and how they will be cared for. You want to protect, especially if you have anyone with special needs that receive government benefits such as Medicaid, SSI, or any other type of benefits. You want to protect their eligibility for those benefits. People who have a little bit more wealth also want to consider tax planning. Most people don't want to give more to the government than you need to. So sometimes, in Maryland, we not only have federal estate tax, we have state estate tax if you're over a certain threshold. So for high wealth individuals, we want to reduce taxes being paid to the government. Planning also, you want to lower expenses of your family, such as if you don't have certain documents in place, that could lead to your family or someone else having to file for guardianship with the court, which can be a long, drawn-out process and can become very expensive. And if you own a business, you want to provide for your business so that it continues to run smoothly, and there are some management provisions for management of that business when you are incapacitated or no longer with us. So why do I need a will or a trust? Again, sometimes people say, well, I have all of my kids are all in all of my bank accounts, or I have beneficiaries named on all my accounts. That doesn't cover anything that may come in after you pass. That doesn't cover things that you forgot about, or if you have a car or you have personal property, what happens to all of that? So you want to determine how your estate is distributed. You don't want the state of Maryland telling your family how your assets are going to be distributed. You get to appoint your executor, or the personal representative, as we call it. That's the person who's going to handle your estate. They're going to file the paperwork. They're going to pay all of the final bills, your taxes, and then finally make a distribution as approved by the court. You will decide who takes care of your minor children or your grandchildren, as the case may be, by appointing a guardian. You can also set up trusts for minor children, special needs children, or other family members with substance abuse problems, because there's definitely situations where you don't want minor children to receive large sums of money. There are situations where you cannot have special needs children or adults receiving inheritance, because that kicks them off of their government benefits, and they are no longer eligible. And then children with substance abuse problems. Statistics show that people who receive large sums of money, who have substance abuse problems, they may be in recovery, and as soon as they receive large sums of money, they go right back to using whatever substance that might be, and then the money is gone rather quickly. You get to appoint a custodian or a trustee for your children or your grandchildren, or whoever you're distributing assets to. You get to decide who's going to manage that money, manage and invest that money for them. And you can disinherit family members. So, every family is different. There are some families where, the parents haven't talked to their children for, 20 years, and they don't want to include that child in their estate plan. And you have a right to do that, because your money is your money, your assets are your assets, and you can decide who to leave them to, whether that's a child, a friend, or a charitable foundation or charity like Benedictine. You can avoid arguments and hostility among family members. Our estate litigation attorney, those are the types of cases that she deals with every day. Our families who are contesting situations where there are no documents in place, or they were poorly written documents that they're fighting over. And then to give you peace of mind, knowing that if you're incapacitated or when you pass, that everything is going to go smoothly and all of your assets will be distributed the way you have and you intend them to be distributed. So the first thing I want to talk about is your financial power of attorney. A financial power of attorney is very, very important. I think it's probably the most important document that every person over the age of 18 should have. As soon as my son turned 18, I had him sign a financial power of attorney because as an adult, if you don't have a financial power of attorney and you are incapacitated, No one can transact your business for you but you. So if you don't have that document in place, you can't call and talk to someone's insurance company. You can't call their mortgage company. You can't figure out, a bill didn't get paid and the insurance should pay for it. They're not going to give you any information. Their investments, if they have a small business, sometimes that business is now stalled because no one has the power or authority to pay the employees, to pay the bills, to get access to bank accounts. So with that financial power of attorney, again, I think that's the most important document to have. In a financial power of attorney, you decide who you want to manage your financial and business affairs if you are incapacitated. So this is only while you're alive. Again, a big misconception is, I don't need a will, I have a power of attorney. Well, power of attorney dies with you. So the day that you die, that power of attorney is no longer effective, and either your will or your trust takes over and comes into play. You give your power of attorney as much or as little power as you want. So you can put restrictions on that power of attorney, or you can give them more broad powers to transact your business. And a power of attorney, as long as it's durable means that even if you become incapacitated, that power of attorney still is in effect. So it is still valid during your incapacity or disability. You can revoke it at any time. It happens quite often that someone has appointed one child or a friend as a power of attorney, and now that relationship is not the same, and they decide, well, I don't want that person, now I want this person. And that is an easy change to make. It gives your agent access to funds if needed without affecting your estate plan. Avoids the need for court-appointed guardian. The courts now are looking at, they've changed the rules, so they want to enforce the least restrictive means. So they want people to have powers of attorney because they don't want to have to appoint court-appointed guardians. A court-appointed guardian is when a person doesn't have financial power of attorney and they become incapacitated. So no one has authority to do anything. Someone would have to file a petition with the court and ask the court to appoint a guardian. The court's going to decide who the best person to do that is. They're going to decide. And then that person files reports every year, but they're very restrictive. You have to apply to the court every time you want to make any major purchase, make any major change with investments. So anything like that, you have to get the court's permission. So it's a very restrictive process. And as I said, your power of attorney dies with you. One of the another common misconception that people come in and talk to me about is that I put my children's names on my bank accounts. I did that. I said, well, you really need a power of attorney. Well, I don't need a power of attorney because my daughter's name is on my account. Well, do you want your daughter to receive all of the money in that account when you pass? Well, no, that's not going to happen. She's going to share it with her siblings. And I tell you, that is all good and well, and that is great intention, but I'm telling you, when the time comes and you are no longer with us and money's involved, 95% of the time it does not happen the way they told you it was going to happen. So the way we solve that is we don't put anyone's name on our bank account. We have a properly drafted power of attorney, which is a legal document. Your power of attorney has a fiduciary duty under the law to do what's in your best interest. And if they misuse or abuse that power of attorney, in Maryland, there's a fairly new law. It got enacted a few years ago called the SAFE Act. And that comes with criminal and civil penalties for someone who uses or misuses a power of attorney. So that's fairly new. But yeah, we want to make sure that your estate plan stays in effect and isn't changed by beneficiary designations. You can give someone power to manage your affairs with that durable power of attorney. Medical power of attorney, living will, advance directive. Again, this is similar to a financial power of attorney, but this is if you are incapacitated or disabled and you're not able to make your medical decisions. So it's a form that designates an agent to make medical decisions for you. And generally, if there's a doctor, if you're in the hospital and you have 3 children, let's say, one child wants to do this treatment, one child wants to do this treatment, and this child doesn't want to do any treatment. Who's the doctor going to look to? They don't know who to listen to because nobody has authority to make a final decision. So in my experience, the doctors are going to do whatever they can do to keep you alive. And they'll make decisions, but it might not be the best decision for you, or it may not be in alignment with your philosophies or your wishes with regard to medical treatment. So you want to choose the person who's going to make those decisions for you. Living wills, also called advanced directives, determine what if any life-sustaining medical procedures that you would want to have. So you can specifically say that if death is imminent, if I'm in a persistent vegetative state, if there is a end-stage serious physical disability or end-stage condition, that I don't want to be kept alive by extraordinary measures, feeding tubes, breathing tubes, just pain medication. Or you can say, I want everything. I want you to do whatever is humanly possible to keep me alive for as long as you can keep me alive. So that's your decision, but it's better for you to make the decision, and make the decision now when you're not in an emotional state, when you're not in a situation where there's an emergency. You want to make those decisions when you're calm, when you're informed, and you're in the right state of mind to make those decisions now, as opposed to when you're in the hospital. So what if I don't have a will or trust? I'm going to go through this a little bit faster. Because people, again, if you don't have a will or a trust, and you die in Maryland, Maryland law is going to decide how your assets are distributed. Or whatever state you die in, that state is going to decide what happens to your assets. So in Maryland, if you have children but no spouse, your children inherit everything. If you have a spouse but no living parents or children, your spouse inherits everything. If you have a spouse and children who are minors under the age of 18, the spouse inherits half of the property and the children inherit everything else. If you have a spouse and adult children who are not the spouse's children, so your children, not your spouse's, the spouse inherits the first $100,000 of the property and half of the balance, and then the children receive the rest. So I did have a situation. I had an elderly woman who came in and her husband had passed. She had come over from Ireland as an au pair. They had met. His first wife had passed away, and he had 3 young children. They got married. She raised these girls as her own for 40 years, and he died. And the house was solely in his name. He never put her name on it. He didn't have a will. And so when she came into my office, I unfortunately had to break the news to her. And this was a few years ago when the number was a little bit different. It was $40,000. And she did not have cash. So she didn't have a lot of cash. She basically had a house that she lived in for 40 years. And the daughters came with their hands open and they wanted their piece. So she had to sell the house that she lived in and give them, she got to keep $40,000 plus half, but she had to give them half of the proceeds from her house. And she didn't have anywhere to live, so she moved back to Ohio where some of her family was. So that was a really sad story, and she was very distraught when this occurred, and basically it broke up the relationships. And I don't know if she ever spoke to those 3 girls again, and nor did they speak to her after they got their checks from the estate. Next slide. So again, if your decedent has parents but no spouse, parents that inherit everything. So I had a young gentleman who actually, unfortunately, he died in a motorcycle accident, and he was newly married. He was married less than 5 years. So the way it worked at that point in time was his parents received 50% of his estate, and then his new wife received 50% of the estate. Again, it was a situation where it became a little bit awkward because you had the new wife and then you had the parents, and the state is telling us how this is divided. Whether that is what he wanted or not, we don't know, because he didn't have a will. So if the decedent has siblings but no spouse, no descendants or parents, it goes to your siblings. Again, sometimes I have clients who say, well, I have a brother, but I haven't talked to him in years, and we don't get along. I don't want him to get anything. And I say, well, if you don't have a will, he's going to get, a part of your estate. Adopted children receive an intestate share as if they are biological children, but foster children and stepchildren do not. They do not receive an automatic share unless you have a will leaving them a portion of your estate. And then if you have a will and no blood, if you don't have a will and you have no blood relatives, the property, it's called escheats to the state. That means that we have to write a check to either the Maryland Department of Health or the Maryland Board of Education. So I've had that a couple times where people didn't have a will and we had to write, $150,000 check to the Maryland Board of Education. Where that money goes, I don't know, but had the person had a will and decided, they could have left that to a charity of their choice instead of it going to the state of Maryland. Naming a charity probably would have, made them feel a lot better, and it probably would have made a difference in people's lives, but we had to write that check to the state of Maryland. So just a couple horror stories I'll go through fairly quickly. And, you think people have these millionaires have, tons of money. They don't have a will. So, if you don't have an estate plan in place, you're not alone. Even ultra wealthy people don't think ahead and don't feel the need to do this for whatever reason. But Amy Winehouse, she didn't have a will. She left behind about $6.7 million. Did she want her brother to receive anything? Did she want to leave anything to a charity? We don't know. Everything went to her parents because she was not married and she had no children. So again, the state decides who's going to receive your assets if you don't decide it for yourself. Michael Crichton, very famous author. He wrote all the Jurassic Park novels. He never updated his will. So he had a 2007 will, even though he was dying of throat cancer and his sixth wife was pregnant. He failed to update his will, and his prior will stated the names of his children. So with that, he excluded any afterborn children. And because it included language disinheriting any future children. So his wife had to go to court, probably spent hundreds of thousands of dollars fighting this. I believe she did win the right for the baby to inherit part of the estate. But again, I'm sure they spent hundreds and hundreds of thousands of dollars in court for her to fight for the right for her unborn child to receive a part of his estate, when more than likely he would have not wanted that to happen. He would have changed the will, or should have changed the will, to include his new child. So when you have a major life event such as birth, death, divorce, adoption, come into a lot of money, anything that's a major life event, we always recommend, even if you do have an estate plan, if you do have a trust or a will, you want to review those documents at least every 5 years to make sure that they're up to date. So many times I have people come in and they're like, oh, I haven't looked at this thing in 15 years. And we said, well, bring it in with you. Let's take a look. And then they've named, their neighbor from 20 years ago as the executor of their will. And they're like, oh my gosh, that person's not even alive anymore. None of these people are alive, or I haven't talked to these people in 20 years. I don't want them in charge of everything. I was like, okay, well, we need to revise these documents and make sure they're in line with what your current wishes are. Etta James. So a will only takes effect after you pass. So you want to make sure that you have a well thought out and well prepared estate plan during your lifetime. And if you're incapacitated, your power of attorney, so your medical and your financial power of attorney, are effective during your lifetime. When you die, your will or your trust takes over. So she signed her power of attorney when she was questionable mental capacity. So her spouse and her son fought each other in court to decide whether that was valid, because she had named one over the other, and then the other wanted to take control. So they went to court and fought over that. And they were in court for a while. Fortunately, she died, I think, before the case went to trial. But again, a properly drafted power of attorney and medical power of attorney are essential to make sure that your wishes are carried out the way you would want them. And again, don't assume that the people that you think will receive your assets will under Maryland law, because as you just saw, that's not necessarily the case. I think we just went over that. Yep. So wills and trusts, people ask me, what's the difference between a will and a trust? A lot of people talk about probate. So they, you know, people come in and say, well, or they call me and they say, well, my mom passed away and she left me the house. And I say, well, then we have to probate the house. We have to probate, which is the legal process of transferring assets from a deceased person to the beneficiaries. And the response is, well, no, we don't have to go through probate because she had a will. And my response is, well, a will guarantees probate. So if you don't have a will, or you do have a will, if you don't have a trust, you have to go through probate. Anything that you own solely in your name at time of death that doesn't have a beneficiary name it has to be probated, has to go through the legal process. That legal process is we file a petition, we have to inventory all the assets, we get appraisals of the assets, we have to file accountings with the court oversees the process, and then the court eventually tells us if we are able to distribute those assets in accordance with the will or the laws of Maryland. Once it's approved, then we get to go ahead and distribute the assets accordingly. So wills, they're less time and cost now, but more time and cost later. They do require probate, generally don't have incapacity provisions, and don't necessarily, unless it's a fairly complex will, doesn't have protection, either asset protection or managerial protection for the assets going to a beneficiary, such as a minor or special needs person. A trust is a little bit more time to create now and costlier, but less time and cost in the future. Does avoid probate. So if you have all of your assets in a trust, it's a private document. It's not filed anywhere. It can include incapacity provisions, and it provides protection for you and your family. So what can you put in a trust? So the way a trust works, people, you know, I get this question a lot. So how does it work? Basically, you put your assets into a trust, and we're talking about a revocable trust, not an irrevocable. That's a whole nother seminar. But a revocable trust is you have complete control and management of your assets. You put your assets in your trust during lifetime. You are the trustee of your own assets. You buy and sell and conduct your business the same as you always do. But when you're incapacitated, a successor trustee takes over and handles your trust assets, management, investment, distributions. And then when you pass, your trust passes. Generally, we pass assets on in trust to your beneficiaries, whether that is a child, a friend, or a special needs person. We'll get into the special needs planning in a minute. But the monies that you pass in trust to someone are protected. So you get the asset protection from future judgments, creditors, divorce, bankruptcy. So a situation where we use trust a lot is in blended families, because a lot of times what happens, people come in and they're called sweetheart or mirror will. So husband and wife, if I die, I leave everything to my husband. My husband dies, he's left everything to me. Okay, I'll pick on me this time. My husband dies, everything comes to me. Well, 5 years from now, I meet someone new. That's okay. I meet someone new and I get remarried. So I've been married for a while and I said, okay, well, maybe I want to leave my new husband my assets. Well, then let's say I die. My new husband gets all of the assets. Now what happens? When he dies, where does it go? It goes to his kids over here, his family. My kids get totally 100% disinherited in that situation. That happens so often. I can't even tell you how many times that happens. So when you have a blended family, these are sometimes awkward conversations to have. I had one yesterday in my office saying, well, what about this situation? Well, what if this? What do you want to happen? Well, what if this scenario? What do you want to happen? So, with a trust, we can create and we can craft these provisions to do what if, then this scenarios, and make sure it all happens exactly the way you want to. You can do it in a will. It's called a testamentary trust. It gets a little bit more complicated because you're relying on your executor or your personal representative to make sure it all happens when you're gone, as opposed to you're creating this while you're still alive. So what can I put in a trust? You can put anything in a trust. Any asset that you own other than an IRA, you can put in a trust. checking, savings, mutual funds, money market, real property, stocks, personal property, life insurance. The only thing it can't hold is a retirement account, a 401k or an IRA, because a trust, an individual has to own that asset. So we deal with the beneficiaries a little bit different for tax purposes. So I'm going to talk a little bit about special needs planning, because I do know either people here or on the webinar have some special needs family members. So when it's very, very important when you are planning for a special needs person or an adult or child with disabilities that you have a proper plan in place. Because in Maryland, I don't know what other states' caps are, but in Maryland, you can only have, and it's all about the same because it's federally, it's a federal program, Medicaid, but every state has its own qualifications. So Maryland, you have to have less than $2,500 in assets. So you have to be basically disabled and broke in order to receive Medicaid. So it happens, again, people really mean well, and there's great intentions where, let's say a grandparent leaves a grandchild an inheritance. So they say, you know what, I'm gonna leave my grandson $100,000. This is gonna be great. Well, as soon as the grandson gets $100,000, he's now kicked off all of his benefits. He's got to spend down that $100,000 and then reapply to get reinstated on his benefits. So instead of doing that, what we can do, we ensure that the purpose is to ensure disabled individuals maintain quality of life without losing public benefits. We want to protect loved ones also from financial exploitation, ensure long-term care, and secure decision-making authority. And the way we do that is use of special needs trust or supplemental needs trust, guardianship, and healthcare directives. So a special needs trust, also called a supplemental needs trust, is a legal arrangement that holds assets for a disabled individual without affecting the eligibility for benefits. It provides financial support while maintaining eligibility for SSI and Medicaid. And there's three types of trusts. But I wanted to kind of tell you how it works. So let's say you have, I'll just do a scenario. If I have one child who's not disabled, I have one child that is, I could leave my non-disabled child money in trust, have a trustee manage that money, make distributions however I want those distributions. Maybe I say, they can have complete access when they're 25, or they can have 25% at 25, 30, 35, 40. Or I don't want them to get a dime until they're 50 or 55. This is going to be their retirement, right? I have a client who their daughter is she works, but she spends every dime that she has. So they came in and they said, you know what? This is going to be her retirement. She's never going to save for retirement. And if something happens to us, how is she going to live when she gets older? So they put all of the money into trust, and the provision was that she could not touch it until she was 60 years old. So it was held in trust, and when she's 60, then she could have access to it. So they basically built a retirement plan for her. And then with the supplemental needs child, that money would go into a special trust. That trust would be held for that child's benefit. And when I say child, I'm referring to disabled adults and children. The trustee can use those funds for health, education, not health. They can use it for anything that Medicaid doesn't pay for. But it still maintains eligibility of that child with Medicaid, because technically the child doesn't own it. The trust owns it. And they don't have full access to it. They don't have control over it. Someone else has control over it. Someone else is making those distributions. So that protects them. It's federal law, these trusts, and that's how we protect, because they don't want disabled people to be destitute. They want to make sure that they're properly cared for, and they give us these strategies and tools to help families care for children or disabled adults when we are no longer here to care for them. So there's three types of trust that we generally use with supplemental needs or special needs planning. One is a first-party trust. So a first-party trust is where the beneficiary must be under 65 years of age. They must have a disability as defined by the Social Security Act. The trust must be funded with assets owned by the beneficiary, such as personal injury settlements or inheritance. It must be established by the beneficiary, their parent, grandparent, guardian, or a court. Upon the beneficiary's death, the remaining funds and trust must be used to reimburse Medicaid for services provided, must be irrevocable. The state that pays out Medicaid must be designated as the primary beneficiary, and they are authorized under the U.S. Code. These types of trusts are called D4A. So the situation is if a person, these trusts are used very often when a person is in a catastrophic accident and they have a disability which deems them disabled under the Social Security Act. But it's their money. So when they file a lawsuit against the truck that plowed into them, that caused a brain injury, that's their money. So they wouldn't be able to get Medicaid because they have too much money. But what we do is we take that, or inheritance. So in this situation, the other situation, inheritance, where the grandparent left the child $100,000. Once that person dies by the will, it's theirs. So we can't say, well, no, we're going to divert this over to this person. It's already theirs. It's vested in them. So they can take that money, either them or through a parent or grandparent, create a third-party supplemental needs trust or special needs trust. We put that money in. The state of Maryland approves the trust, and then they still get their Medicaid. They get the Medicaid and all the government benefits, and the trustee can use the funds in the supplemental needs trust to pay for education, transportation, education, vacation. They can buy them a car, they can pay for clothes, they can pay for co-pays, they can pay for everything except for what Medicaid pays for. So whatever Medicaid pays for, they can't pay that, but they can pay everything else. So it's a great tool and strategy that we use when people become over-resourced and they are in jeopardy of losing their Medicaid. So why they work: it protects the government benefits while providing for additional needs. The Medicaid payback provision ensures that Medicaid is reimbursed, but it ensures that the individual benefits from both personal assets and public benefits during their lifetime. And I forgot to mention, the one reason it does work is because Medicaid's saying that you have this money and we're going to let you put it over here in this trust. We're still going to pay. We're going to give you benefits. But when you die, we get reimbursed. You have to pay us back. So that's why the first party trusts are permitted, because Medicaid will get paid back. So the next one is a third-party special needs trust. Third-party special needs can be set up during the benefactor's lifetime or through a will. It's funded by assets from a third party, such as gifts, life insurance, inheritance from parents. You can't use your own funds to create these. Again, the beneficiary must have a disability that significantly impairs their ability to care for themselves, and they have special needs and expenses that the trust can help with. So this is if you decided to do this now, while you're still alive. You would say, okay, this is my money. I have $500,000. When I die, I want my $500,000 to go to my child, thank you, who is a disabled adult. But I'm saying that this money is going to go into a supplemental needs trust. So you're just telling, in the document, you're saying, this money goes to a supplemental needs trust. It's my money, but I'm putting it in this trust for the benefit of my child. That's a third-party special needs trust. Go to the next slide. So again, the trustee, in this situation, again, the trustee has full discretion how to spend the money, manage the funds for the disabled adult or child. Anything not covered by government benefits, like I said, vacations, education, transportation, personal care, recreation. In this situation, the trust does not have to reimburse Medicaid because it's not the beneficiary's money. So it's not his money to do with what he wants. It's your money, and you're saying it goes into trust. I want this money to go into trust for the benefit of my child, and then when my child passes, then I decide who it goes to, his siblings or charity or whoever else I want it to go to. So that's the big difference. And again, that doesn't apply to this because Medicaid doesn't get paid back, so we'll skip that one. So in the first party, so again, just to recap, so the first party is the disabled person's money they're putting into a trust, and the way it works is because Medicaid gets reimbursed. Third party, it's someone else's money that's going into the trust, and Medicaid does not have to get reimbursed. It goes to whoever you say it goes to at the death of the disabled person. The third type of trust is called a pooled trust. And a pooled trust is, again, for a person who's considered disabled. A pooled trust has to be established before the person turns 65 years old. And it is established to, again, make sure that the person remains eligible for benefits. And this is generally called a D4C trust. The first party trust is called a D4A. This is called a D4C, which is under the US code. In a pooled trust, the money is paid to a nonprofit organization that invests and manages the money. So the reason why they have the under 65 is it gives the investor, the nonprofit, it gives them time to invest that money. So it's just a big pool of money, and each person has their own share of that pool. So the assets are pooled for investments. It's ideal for smaller amounts of money. If you have, $100,000, a lot of corporate fiduciaries, they're not going to manage $100,000. A lot of times they have $1 million minimum. And then you just have to make sure you're choosing the right nonprofit. My associate attorney, her name is Sharon Bell, and she focuses on special needs planning in our office. And she actually came to us from a company called First Maryland Disability Trust, they had a pooled trust. So they would hold money for special needs individuals, they would invest that money, and they would manage it in accordance with the statutes for special needs or supplemental needs trusts. So again, any money held in a supplemental needs trust is not considered an asset for Medicaid eligibility calculations. They do need to comply with both federal and state rules with regard to the provisions that are included. And you want to be sure that you're avoiding any pitfalls that would disqualify beneficiaries from any of these programs. So just to talk a little bit about guardianship, we touched on it, but it appoints someone to manage decisions for the disabled individual. A power of attorney, also, if the person has some capability, they can sign a power of attorney appointing someone to make financial decisions. And you want to make sure you pick a trusted individual to be the trustee. Well, with any of these, you want to make sure you pick the right person to manage your money. You don't have to have the same person to manage your money and make medical decisions. You might have someone who's really great and financially savvy, but you don't want them making your medical decisions. And you might have someone who you really want to make your medical decisions, but they're terrible with money. So you just want to be careful who you're choosing, because each role has a different purpose, and you want to make sure you're picking the right person for the right role. With supplemental needs or special needs planning, it's also important to ensure coordination with other family members' estate plans. You can fund with life insurance, inheritance, or gifts, depending on the type of trust. And you want to update the plan and be aware of any tax consequences. So special needs planning ensures your loved one's financial security and you want to make sure that you have a consultation, you get the right plans in place, and then you properly fund that plan if that's what you're going to decide to do. Excuse me. So I know there are some questions. I know someone had asked me about real property and how to protect that real property, but I don't remember what the question was.
Just in general with real estate, I mean, you could put an LLC. You could have your spouse join in tenancy.
Mm-hmm.
In this case, it was my spouse.
Right. So with
Trust.
right. So with real property, you can hold real property in several different ways. So yeah, that's a good point. So you can own it as tenants by the entirety if you're married, which gives you some protection. So if one spouse is sued and gets a judgment, they can't take your house because it's owned by the marriage, not the person. It's tenants by the entirety. Then you have tenants in common. Tenants in common means that I own property with you, I die, my half goes through my estate, your half goes through your estate. So that's tenants in common. So it's separable. You have joint tenants. We own it joint tenants. If I die, you take all. If you die, I take all. So there are very serious consequences depending on how you word deeds and titling of real property. So when you do own a property or buy a property, you want to make sure you have the titling correct and it's going to do what you want it to do. Another way to do it, if people have rental properties, sometimes I recommend that they have them in an LLC, and then the trust owns the LLC. So we have the trust umbrella, and then you can have LLCs underneath the trust. So if a property, say if you have 5 rental properties, and you don't want to get, you're afraid of getting sued, you put them in an LLC. So if someone does, get injured and sue you, they're suing the LLC because the LLC owns it. So the only thing they can get to is that property in the LLC. They can't get to all of your personal assets. But the trust can still own the LLC. That keeps it out of probate because you don't want that LLC going through probate through the court system. But if the trust owns the LLC and then the LLC owns the property, it's still all in that wrapper and it avoids probate. The other one is a life estate deed. We get that question a lot. So a life estate deed, and it's allowed not in all states, most states now. A life estate deed is where I own my property, but I want it just to go outside of probate. I want it to just be owned by my child when I die. So I can prepare a life estate deed to my child, reserving a life estate to myself with full powers, meaning I own it, I can sell it, I can give it away, I can mortgage it, I can do whatever I want with that property. But the moment I die, the deed's already recorded, it goes to my child.
Lifetime estate?
A life estate deed.
The term I've heard is lifetime estate. Is that the same thing?
I don't know. In Maryland, we call it a life estate deed or a ladybird deed.
This was the person generally owns it for their lifetime.
Right. Okay. That might be the case. It sounds like it. So you can have a life estate with full powers and no powers. I rarely do no powers. That's really tricky when you get into that because basically you're giving away your property and I'm saying that I only have the right to live in it. That's all I have. I have the right to live in my property, but I have no power to sell it, no power to mortgage it, no power to do anything. So a lot of times these people come to me and they say, oh, I have this life estate deed, but there's no, and I've said, okay, well, there's no powers. They say, well, I want to sell the house because I want to move to a little condo down in Florida. And I'm like, well, you're going to have to ask your kids because they have to consent. And if they don't agree, they don't have to. And so you could be stuck with that property or otherwise limited because they don't want to let you sell the house because now you have the money and you can go spend it, right? But if they say no, they're just waiting for you to pass away and they get the house. So these things happen in real life. This happens, I've had all of these issues come to my office in the last 25 years. So I've seen it all. Any other questions?
Kristen online asked, is it possible to get durable power of attorney / healthcare instead of guardianship if the person living with disabilities cannot fill out or understand the paperwork?
No. So if the person is incapacitated to the point where they don't have legal capacity to sign legal documents, then no, you would have to get a guardianship. But I do have a situation. But the criteria is you just have to have a moment of lucidity. So if you can understand, so people come in with maybe some early signs of dementia, or older people have dementia, but like, sometimes, one day they're really great. They know what's going on. They can tell you everything, but the next day, not so much. Or in the morning, they can tell you everything about their life. By the time the afternoon comes, they don't remember what they had for breakfast. So as long as the person, at the time they're signing it, they say, yes, I know what this is. Yes, I want this person to be my power of attorney. I understand what this is. They sign it. It's valid and effective. They might not remember it the next day, but the moment they did it, they didn't understand it. So it would be a valid power of attorney. Question?
Can you have like joint power of attorneys?
Meaning appoint two people?
Yeah.
You can. I recommend, for medical, it's not as big of an issue. With financial, you can do it. We recommend having one, just because banks are hard to deal with. I had someone call this morning, and they said the bank won't accept the power of attorney because there's two people named. I'm explaining to her that it's against the law. They have to accept this, but they're not accepting it. So we might have to, send a strongly worded legal letter to the bank saying you have to accept this. But it's causing problems because they need the money to pay for their sister's assisted living, and they can't get to the money because the bank won't accept the power of attorney because they said it has two people on it. Now they went to another bank and had no problems. So it just depends on what bank you're dealing with.
I had sole power of attorney, and I had a hell of a time getting banks to take it on. Because at that point, there was a lot of fraud going on both sides. I finally found one bank that would take PNC.
Those banks have their own power of attorneys.
Well, they do, but then you can't. I mean, if you're a person doing an estate plan, you can't go to every bank and sign an individual power of attorney. They do have the Maryland statutory power of attorney form now. So any Maryland bank has to accept the Maryland statutory form power of attorney. The legislature wrote the language, and the banks have to accept that. So that is, sometimes you'll have two. You'll have the statutory, and then you'll have a more comprehensive, because the statutory doesn't have all the powers that we might need for, let's say, Medicaid planning or long-term care planning. We have to have some broader provisions, but they have to accept the Maryland statutory power of attorney.
Just like there's a federal state tax exemption. What is it for Maryland?
$5 million.
How much?
$5 million per person.
5 million.
Right. So you can, so if you die and you have more than $5 million, you're going to be subject to Maryland estate tax, but not federal. If you have right now, it's 13 point something million dollars per person. And that's the federal.
And 5 million is per person?
Per person. That's supposed to sunset though. So that's sunsetting next December 31st, depending on who's in office. And if they extend that Tax and Jobs Cut Act, which raised the federal tax exemption, we're expecting it's not going to be, and we're expecting it's going to come back to around 7 million per person. So it's going to be more equal with the states. So it will probably be federal and state is going to be around 6 million per person. And if you don't do any planning between now and then, if you're over those limits, then people pay up to 45% of your estate, almost 50% of your estate in federal and estate taxes if you're over the federal limit.
Oh,
so if you have more than 13 million, you're paying 50% of your
the
estate.
subject of probate. If you have everything in probate, you forget one item. Still have to go to probate court? Or no?
You have to probate that one. If you have everything in a
Just
trust,
one item.
you have to probate that item.
It doesn't negate the whole.
No, no.
I thought so.
No, because often you have things in trust, but you might get a tax refund after you die, or you might get, a bank account you forgot about, or a car. You just probate that asset, and it pours. We call it pour over will. It just pours right into the trust.
Mm-hmm.
I still have a 10% penalty for non-related inheritors.
Yes, good point. So Maryland does not have inheritance tax for direct descendants. So you don't pay an inheritance tax for parents, children, grandparents, stepchildren, or siblings. Anyone outside of those categories would pay 10% inheritance tax. So a niece, a nephew, a friend. Charities do not pay any tax. So if you leave money to charity, doesn't pay federal estate tax, Maryland estate tax, or inheritance tax. So charities take with tax-free. And you have a lifetime gifting. So another strategy we use if you are close to, or if you just want money out of your estate, or you're getting close to those tax exemptions. So let's say I had a client who she's almost at about 5 million. Her husband passed away and she's single. She has almost 5 million. So we don't want her to get over that 5 million because we don't want to have to pay it to the government. So what we did was we did 2 irrevocable trusts for her 2 grandchildren. And she put a few $100,000 in each of those irrevocable trusts for them to have it for college and anything else. We therefore got that money out of her estate now, and she's not gonna have to pay tax on that. So there's lots of strategies that we can use to deal with all of these issues.
What happens if the executor or the trustee, if it's a family member, they die before you've done the trust and they die, then you die? Or if it's an attorney that you named and they retire?
Usually, well, we always have our clients name a primary, a first and a second. So we always have a first and then a successor, trustee, power of attorney, executor. But if you did name an attorney, as long as their firm is, generally if their firm is around, the firm would step in. But otherwise, the court would appoint whoever the closest relative is or whoever applies, who's in line under the statute, whether a spouse or child or sibling.
What do you recommend to your clients in terms of the criteria as far as naming an executor and power of attorney and medical?
Medical, you want that person to have the same philosophy as you. So if your philosophy is, I want to be kept alive, I want the doctor to do everything to keep me alive, don't appoint your child who's like, pull the plug, that's their philosophy. You don't want to appoint that person, and vice versa. If you have someone, more than likely it's people who, they have the child who's very sentimental. They're like, I can't make this decision. It's going to be too hard. I'm not going to be able to do this when the time comes. You don't want to appoint that person. You want to appoint the person who's going to be able to make that decision. Financially, you want to appoint for your financial power of attorney and your trustee or executor, someone who's very organized, someone who's responsible, someone who's, fairly good with money, because even kids fight over, well, why didn't mom appoint me? Why did she appoint you? It's a job. People think it's an honor. It is not. It is a job, and it takes so much time for people sometimes to administer, and they realize they come in with like big boxes of stuff, and they're like, I never knew how bad this was going to be, and like, Kira, can you do this for me? And they're just bringing in bags of paperwork. So unless they just should be organized and just responsible,
Well, are there companies that offer these services
besides
a lawyer, besides a bank?
As a trustee, as a trustee or a fiduciary, there are some professional fiduciaries. They charge a little bit higher fees, but for a power of attorney, I know one company in Northern Virginia that, they specialize in special needs planning for people who don't have someone else to do that job. Because that one you don't want to screw up, because if you start paying the wrong bills, you could lose the eligibility for special needs planning. So that you might want to have a professional fiduciary, because they know what they're doing and they do it all the time.
And do you recommend or notice any resources on the web to really read and really bring yourself up to date with these things? As a layman,
You can go to our website. I think I planted you there now. We do have a lot of free guides on our website. We have long-term care planning, probate in Maryland, family protection checklist. So we have a lot of free brochures and guides on our website. But I do know like the Department of Aging has a lot of information. The Register of Wills actually has a lot of information for probate matters. That's all I can think of at the
You
moment.
look on the web and there's everything.
Yeah.
Of course, I own real estate in another state, live in Maryland, and I'm licensed in another state.
Mm-hmm.
So what is my state of residency?
Well, it's where you're domiciled. So wherever you have a driver's license, where you have a home, where you have most of your personal property.
Three different states.
I guess it depends on where you die. Then it might be
Not four.
Yeah, it depends. They could probably pick a jurisdiction. It's probably whatever's the best process. We could probably say, well, you have enough of a connection to the state of Delaware that we want to probate it there, or you have enough of a connection to Maryland, we can probate it here. One thing, you did bring up a good point that just jogged my memory. If you have properties in multiple states, you will have to probate the property in every state. So that's another reason why people have, if you have properties in multiple states, I recommend a trust. You put all the properties in one trust, you have no probate. If you have a property in Florida, you have to do an estate in Florida for that property, one in North Carolina for this one in Maryland, one in Delaware. So you have 4 estates going. You have your primary, but then you got the 3, they're called ancillary estates.
The trust law is fairly consistent. I imagine it would be because they apply with federal law.
The trust laws, yes. I mean, some states have their own trust act. Most of them follow the Uniform Trust Act. Maryland's does. We might have a little bit of some different criteria, but for the most part, they're fairly similar.
The question is a little bit off track. I have a personal situation with my father passed away several years ago. He had a will, and in this will, there's provision for my sister and I to inherit their home, the home.
Mm-hmm.
After my stepmom dies. She's got lifetime rights. Lifetime rights. However, what's happened is she's showing lots of signs of dementia. And there are things that she is spreading around that are not true.
Mm-hmm.
In her mind, I'm the money grubbing daughter who's trying to get everything regardless of how it occurs.
Yeah.
She claims that I've said things that I've never said. And so anyway, this has just come about within about the past year.
Mm-hmm.
Is there anything, if we get to that time, is there anything, do I have a leg to stand on as far as if she tries to do something that's totally against what my father wrote?
Well, yeah, I mean, she can't do that. So I would have assumed that through the estate that there would have been a deed recorded that says that you get the house, but she has a life estate with no powers, and that's already been recorded. So you should make sure that's been recorded, and that's already on record. So she can't sell the house, she can't mortgage it, she can't do anything because it should be on record. If it's not, then I would have concern about that. I would be concerned.
How would I find out if they do?
You just did land records. We could pull the deed from land records to see what the most recent deed is.
There are 2 questions online. First question is there a big difference between a special needs trust and an able trust?
So there's an able account. So you can have a special needs trust, but you can also have an able account. So an able account is where you can put up to $100,000 into a special bank account. And that's for the benefit of the disabled person, which can be outside. So it's a little bit more, less restrictive, but it's easier to access. But you can have both. So they're complementary.
Okay, and second question, how do you avoid your money going towards medical supplies?
Well, if you're receiving Medicaid, your Medicaid should pay for the medical supplies, and you wouldn't use this money in a supplemental needs trust to pay for medical supplies if Medicaid pays for it. Yeah, but you can use that money for co-pays, like medical co-pays, anything that the Medicaid doesn't cover. You can use the ABLE account or the supplemental needs trust money. Okay.
I got one other thing.
Okay.
Does an executor have the authority to sell real estate without the consent of the other siblings?
Yes, the executor is in charge of everything. They decide how it works once the court appoints them as the executor of the estate.
And then you as the buyer don't have to wait until the estate is settled in order for title search purposes or anything like that?
Oh no, we sell properties in estates all the time, the executor, yep. And that's how you liquidate assets, because you have to do that in order to make the distribution.
And
Yeah.
my reading and some experience has been where the heirs get it, the heirs are in Florida, across the country, and the house is like a don't wanna situation. Or just dump it, just sell it. You see that a lot.
Well, they'll sell it. I mean, you have to sell it for fair market value, whatever the market bears. And you sell it, might take a loss, might make a gain, it depends. But then you sell it, and then you distribute the cash pursuant to what the will says.
The heirs, I'm used to the heirs where they're greedy and they want every nickel of the value of the property. But I've also read where there's a lot of cases where the houses don't want to just sell it. I don't care about the.
Well, you're supposed to sell it at fair market value, and if you don't, the other heirs or beneficiaries have a remedy. They could file a petition with the court, and then the court can say, no, you can't sell the property for that, or you're responsible for the deficit because you didn't sell it. You sold it for less than fair market value. Well, thank you, everyone. Thank you so much for coming. So I hope you got some good information.
Thank you.
And if you have any other questions, feel free to reach out.
Thank you again. We will be emailing out the slides that Tara provided, and we will also have the live stream available for you guys to watch. And we'll be following up with a little survey just to ask what you thought. And if we can refer you to Tara or an attorney or help in any way, if you'd like to learn more about Benedictine, just let me know. Again, I'm Claudia Cunningham, and
You have your own attorney in-house?
I'm an attorney.
She's
No,
with
like-
We have 5 of them. We have 5 attorneys, yeah.
That's what I meant.
Yeah, I'm one of 5.
So thank you guys all so much for joining us tonight.
Thank you.
Thank you, everyone.